The American Adoption Congress, 13th International Conference, April 11th to the 14th, 1991 in Garden Grove, California. This is program number D151, tape 27B.
I find out a couple of months later, she tells me, no, Joe's not the birth father, it's really somebody else, but I really don't want to get involved with him anymore, I'm sorry. So now I've got unknown alleged father number one, in addition to Joe. Then we go through her file, and I talked to another attorney who worked with her 2 years prior on another adoption she was involved in. This poor woman had been pregnant 9 times, had 3 children that were living with their paternal father, had 2 children that were placed for adoption, and all the other pregnancies ended in abortion. And she refused to have her tubes tied after the last delivery for some reason. Don't ask me why. An otherwise intelligent, humorful person who I really enjoy working with, but when it came to this issue of pregnancy and adoption and some other alcohol and drug problems, she was not functioning at a high level at all. In that case, I learned that 9 years ago she was married to somebody, but thought she was divorced and was not divorced. So now we have the fact that the unknown birth father is the father of the child according to her, but the presumed father is the husband that she forgot to get a divorce from. So now I have to get either his consent or terminate his rights. So that's where the law has made a mess of things. Because where's the truth in all that? I had to go through all these machinations of petition to terminate rights of alleged unknown birth father. And that was an order that it was just signed by the judge. There's no problem getting that. But the Social Services Department had to track down her husband, who didn't know that she was pregnant and obviously was not the father because he'd been in jail for 4 years. But he got released the week before I needed him. And he was nowhere to be found. So I had to do a publication in a newspaper for him, and on and on. So the practice of adoption that people think is just such an easy, slam dunk, a happy, wonderful experience for the lawyer, became a procedural nightmare for me because of these distinctions, these artificial distinctions between presumed, alleged, and actual birth fathers. I want to bring that up because a couple of years back, the McNamara case, the Ed McNamara case in California here, almost got a case to the Supreme Court of the United States where they would have to deal with the issue of, well, are the rights of an alleged or presumed father different, the same, or what are they? But because of the way the case was presented to the court, this was, I forget who was the Chief Justice at the time, they dropped the ball, they passed the buck, they had the opportunity to deny certification of the case and not deal with it. And it might take, I don't know, another 5 or 10 years before a similar fact situation and a plaintiff, again, who can afford the legal process to have that type of case considered again. So now, the legislature is still grappling with these things. And, for those of you who might be confused about these distinctions, one of the reasons why they draw this distinction between an alleged father, and by alleged father, the 99% of those alleged fathers are the unwed birth father cases. So if you're not married to the birth mother, you're an alleged. You fall in this category. Well, adoption practitioners of past decades got the legislature to pass the laws regarding these alleged fathers. And it's in the Uniform Parentage Act, which is probably the law in 45 out of 50 of the states. So this law is in your books somewhere, in the Civil Code or other family law acts and things like that. That's the law that says that if you have an alleged father, if you know who he is, you have to give him notice and either get his waiver or get his consent, or if you've given him notice and there's no response, then in a certain period of time you can bring a petition to terminate his rights. That's what I'm talking about, okay? But if, on the other hand, he was presumed in any way a father, either one who was married or attempted to marry or some other categories, and then here we turn on facts, one who has admitted paternity, has held the child out as his own, and here's the clincher, has received the child into his family. Well, how does a father receive a child into his family? We're talking physical receipt, because there have been cases that dealt with constructive receipt. Well, I went to the hospital, I visited the child, I tried to bring the child home, but my girlfriend, gave the child to the couple or placed the child with the attorney. I couldn't receive the child. Well, courts have held that that's not receipt of the child into the family. So how does an alleged father rise to the status of presumed, and the key there is the presumed father in adoption, his consent is necessary to the adoption. So the distinction between those two categories is very, very important, because if they can be blurred, and there are what we call, what we want, equal rights for fathers, then all fathers' consents will be necessary to the adoption. Obviously, this will make the attorneys and the social workers' job a little more difficult. You'll either have to get the consent, you'll either have to give notice, get the consent, or do some kind of termination. And that, as Jim said, will force the birth father into the process legally, but that is not the law of the land, and not the law of most states. So legally, there are loopholes, and obviously the biggest one is to counsel birth parents not to name the father. Don't worry, you don't have to name him. If we don't name him, we don't have to give him notice, we don't have to give him a consent. We file a petition to terminate the rights of unknown birth father, and the judge signs it and stamps it, and everybody goes home and, you're on your way. That happens in a lot of cases.
What about the challenge? What about the birth father discovers it and says, hey, wait a minute.
Okay, but what about the challenge? But what are the odds?
Oh, yeah, the odds are.
The odds are long.
Yeah.
Okay, and I want to talk now about the cases that have come along where the birth father has challenged and succeeded, and it's happened. So this is it's a trend, and it's one that the law has given the birth father, again, the opportunity, but again, it turns on the facts. And the question is, as we were discussing before, and Jim mentioned it too, what's in the best interests of the child? That is a standard that has been applied in all the custody cases around the country. When you get to a challenge between either a birth mother who's changed her mind about the adoption, or a birth father who comes in and says, I want to parent this child, then the court is faced with the issue of, well, now what do we do? Here we've got some dual situations. We have a paternity action. First of all, is he the father? And if they make an order that he is the father, is his consent necessary, or should his rights be determined based on what's in the best interest of the child? And if you plug that formula in and you put it on a scale, and you say, well, child's been in with adoptive couple A and B for 6, 7, 8, 9 months. Birth mother's consented. She wants to be out of the picture. But if the birth father can, as you say, make this challenge, will they get together? Will she be a single parent? Will he be visiting the child? What if she doesn't want the child? Can he parent that child alone? Well, if you take Mr. Average birth father, who might be a young man of limited financial means, and put him on that scale of justice with a couple, wonderful adoptive couple number 2, who do you think is going to win? 9 times out of 10.
State.
Not the state. Adoptive couple. Because best interests of the child is number 1. You get the psychological experts in to talk about bonding and attachment. You get the financial status. Obviously, they've gotten through the home study and the adoption process. They've been married for 15 years. They have other children who treat the child as their sibling, and they're both employed. They earn $50, $60, $70+ a year. And here's Joe high school student saying, I want to parent this child.
What you do is you get a judge who believes that blood is thicker than water.
Well, there are some of those judges too, but not many. And there's no parental preference for the birth parent, okay? But what has happened in this Germstad case is they did apply the best interest of the child standard. And in that particular case, the judge ruled that even though the birth mother was out of the picture and the adopting family had the child for 6 or 7 months, that Mr. Germstad, who had gotten married and would be away at sea as a merchant marine, had a family that the child could also thrive in. So in that situation, he lucked out on the facts. But there's a new line of cases that dealt with birth mothers' rights. We're calling them the BMW trilogy because it's baby boy B, baby boy M, and baby boy W. What happened in those cases for the birth mothers who were changing their minds or challenging adoptions was that the court said that any time before the consent is signed, and this is California now, okay, but any time before the consent is signed and the birth mother signs a form that the DSS has called the refusal to consent to adoption, she has retained her legal rights to the child, and almost automatically the child will go back to the birth mother without there being a custodial hearing regarding what's in the best interests of the child, and she will not be measured against the adopting parents. So the best interest of the child standard for birth mothers who've changed their mind about an adoption and who have not yet signed the consent. This is not in revocation of consent cases. Please understand the distinction. There will be no television cameras of crying adopting parents and publicity about, home wrecking or whatever. The child is still the birth mother's. So again, if we look to the constitutional line and say, wow, birth fathers have been given some due process rights, notice, and an opportunity to parent, are they also going to be given equal protection? Because what I'm saying is, and I see this happening in the future, if birth mothers who originally planned for an adoption can change their minds about an adoption plan, their consent is required, don't have to have their rights weighed against the prospective adoptive parents, then if the birth father comes along and he wants the opportunity to parent, will he then not have to make a showing that he's a better parent than this couple who's had the child for any number of months? That question has not yet been answered, but I think it will be. If the distinction between the presumed and alleged parent is out the window. It's not happened yet. People fear that this will bring back what used to be the law in the 40s and 50s, the blood parental preference, which has been thrown out the window by statute. Should there be a parental preference for a natural parent simply based on the bloodlines and genealogy? People have different opinions and it falls down on both sides. Yes?
Is that handled case by case?
What I'm saying is they're all handled case by case. And I mentioned the Germstead case, which recaps all the constitutional law cases, where that father won and got custody. The only case that was a May 1989 case, the only case that followed or mentioned the Germstead case came down in January of 1990, and the father in that case did not win custody because he was a convicted felon and he was an inmate at a prison. And I'm saying they turn on the facts. It depends on the plaintiff. I've personally had a case recently in the same county in which the Germstead case originally started. That was Santa Clara County. And my client was a young man, 22 years old, a college student. His girlfriend was working with a high-powered independent adoption attorney. He claimed he was against the adoption from the start, but she went ahead. She took money from them for living expenses and felt duty-bound to go through with the adoption. And he came to me when the baby was 4 months old. He had another attorney doing some things. We had an order of paternity establishing him as the father. And then we went to this evidentiary hearing on what was in the best interest of the child. And it turned out, unfortunately for him, that some of the things he was saying about his relationship with her and his actions and his conduct in certain ways and a drinking problem were hidden from me. And the judge, based on those facts, made a determination that the baby was going to stay right where she was. So it really depends on who the plaintiff is. And that's the discretion that a judge has on the trial court level. These other cases are all appellate cases that turn on interpretations of what the law is. Yes, sir?
Have you ever had cases where some form of a compromise where guardianship is allowed?
Not usually a guardianship, but an open adoption arrangement. I had a case where a birth mother placed a child with 2 gay women, and knowingly. And then as the open adoption arrangement progressed a little bit more, and she visited the child every couple of months and got to know the partner of the woman she placed the child with, there was some friction between them, and she decided this might not be such a great idea after all. And she tried to revoke her consent. And much to my surprise, in, I think it was Sonoma County, the judge and the social worker report was favorable to the gay couple. It was a boy child also, which I thought perhaps would give an edge to the mother who's had some fears about how her son might be raised in a lesbian environment or something like that. And then I did some reading on gay parenting rights, and I thought, oh, well, gee, maybe my initial thoughts about this case are a little wrong, and it taught me a lot. We went to mediation, and a mediated solution was brought out because it was my feeling that after the report came down against my client that the handwriting was on the wall and we would lose the case. So what they mediated was how their relationship was going to continue and how the adoption was going to remain open. But the open adoption solution to some of these custody cases is always the suggested one. When can't we work this out thing instead of the judge having to decide, make the hard decision. Yes?
Are you saying that the presumed father, though, even now does not have to have a test against the adoptive parents? And that automatically his rights are preserved?
Yes, because he must consent.
Okay, and are you also saying that you can be a presumed father by simply admitting paternity or by trying to marry the woman? Did I misunderstand that?
There's a statute in our state, it's Civil Code Section 7004, which tells how a presumed father status is obtained.
So that might
One
be
is to
different
be
in another
married.
state?
No, but what I'm saying is that's part of what's called the Uniform Parentage Act,
Oh, okay, so that is part
which
of
is
it.
which has been adopted by 45 of the 50 states or so.
Yeah, that's incorrect.
Right. So you have a presumed father by either marriage, okay? There's a presumption that a child conceived during a marriage within 300 days of cohabitation is the child of the marriage, whether or not the woman has had an affair with, any number of people, okay? But if she got pregnant by somebody outside the marriage and decides to place that child for adoption, the husband is presumed to be the father. His consent is required for the adoption.
Yeah, what you said that was new to me was, though, that possibly an unmarried father
Could rise to the
could
status.
rise to that
Sure.
status
By having these
tried
things.
to marry the woman or
No, not tried to marry the woman.
Okay.
It's that they went to a ceremony that was performed and it turned out not to be the right kind. That's one type.
Oh, okay.
Okay? But the other factors are to hold oneself out as the father during the pregnancy, to say, Mary and I are expecting, and all the parents know, and all the friends know, everybody knows that he's, said he's the father. It's almost like a common law type marriage situation. Mm-hmm. The other is to be named on the birth certificate with your consent. And those are all and things. I mean, there's a bunch of them down the row. If any one of those factors is missing, it doesn't exist.
Okay.
The other thing is that evidence code presumption of that presumed fatherhood status from the marriage is also another area that's come up for review. And so far, our California Supreme Court has upheld that presumption that a child conceived of a marriage or within 300 days of a marriage is the child of that father. And there's been some unique cases. I was involved in one of them in San Francisco where a birth father came forward. This time I found myself on the other side of the fence, unfortunately. I was representing the birth mother. She wanted the child adopted. She was married to somebody else. We wanted an order saying that her husband was the father of the child and his consent was valid. And then we had a birth father from Arizona that she had a casual affair with coming forward to assert some parental rights. And the attorney who was working with the adopting couple wanted to make sure that this evidence code presumption was upheld, even though we knew that the husband was not the actual father. And it was. But I had some mixed feelings about that because I think that presumption is an absurdity. But that's the law. One other thing I want to say, I don't know how we're doing for time.
Losing time.
Okay.
About 10 minutes to go.
Okay. I wanted to say that, as I said before, you've gone around a lot of the things that I wanted to talk about in general. Having the birth father involved in the adoption process obviously is a goal that we're all talking about. And we've talked about what happens when he's not involved. That's when some disaster can happen. And I've talked about the constitutional rights. I mentioned these cases where the birth mothers are spirited away to Canada, unfortunately. And the fact that all these cases turn on the individual facts and the character of the people. The other thing is this entitlement issue that I know that's what John Ryan wanted to stress, was trying to figure out, well, what are the rights of these birth fathers really? I mean, shouldn't there be a basic constitutional right to raise your children, your offspring? Some of the attorneys and legislators who've passed these restrictive laws which limit the rights of the alleged fathers, one of them in particular, has called birth fathers casual inseminators with no rights. And this obviously cuts at the biological process involved in the conception and pregnancy of the situation. As we all know, and we see from our membership of our organization, and I've always felt this, adoption is a feminist issue. Females are biologically involved more in the birth process than men. And men, as we pointed out, have this opportunity once they conceive a child to either leave on their own accord or be left out of the process, either by the birth mother or by the people that the birth mother comes in contact with. So the feminist movement and the power of the woman to control the situation is what impacts on the birth father's rights here. It's also, again, the societal conceptions of what is going on here. Who should parent? What's right for this child? Now, traditionally, agencies have been in the role of a helping profession, obviously, regarding the whole birth, pregnancy as a problem that needs to be solved. You've got a problem here. We have the answer. The answer is adoption. Well, if that's your basic assumption, as we pointed out, then how does the birth father, as I said before, stop that big train, with his own little body? He is powerless to do much, but the law has come along now, and there is a trend, as I've said, to accord him some rights. The rights are the notice of the proceedings, the opportunity to come forward, and as has come up before, to take responsibility in some way. And if he does want to do that, as I pointed out, and I keep harping back to this, the timing is critical. The timing is critical. Yes, sir?
Martin, 6 years ago, when I found out my son was adopted, his mother and I were considering trying to obtain custody of him again.
It wouldn't have been possible.
Okay.
There's a statute that, in some states, the time limit varies. But what you would be talking about is vacating the adoption order on some grounds. And there are statutes in every state that tell you what the procedure is for filing a petition to vacate the adoption on grounds of. And it's very limited. One of them would be fraud, obviously. You didn't know what you were signing. You were coerced or pressured into signing physically or emotionally or financially induced. The whole adoption is a fraud. Chances are you don't have the facts to have done that, and also the statute of limitations on those things. And it's a good statute. I mean, to protect the integrity of the adoptive family, as we said before, even if another father comes along 2, 3, 4 years after the adoption, you're not going to go back into court and say, well, no, we made a mistake, we had the wrong guy, this is the guy, now we've got to terminate his rights or get his consent. No. When the adoption's final, it's usually 2, 3, in some cases in our state, it's 5 years down the line. Petition to vacate an adoption can be brought, but it has to be proven that you have the grounds and the reason to vacate, reverse the adoption order. And there are some cases that have done that. A lot of medical cases, for example. It's kind of sad. I mean, there have been cases where adoptive parents themselves, this is what the statute was started for, can vacate an adoption of a child they didn't know was carrying a genetic disease that is going to require them to pay hundreds of thousands of dollars of medical expenses or whatever. And they go into court, they reverse the adoption, the child becomes a ward of the state, and then the taxpayers pay the bill.
I'm just so appalled now of hearing more and more of these cases
Yeah.
coming about. where the adoptive parents,
Right.
think they just have a bad seed, or the
Right.
child doesn't live up to their
Or cases
expectations.
where if, under any other circumstances, as a parent, if we're having a tough time with the child and we, say, I can't deal with him, he's yours, take him back, that's the hand we were dealt. And if adoption is supposed to be just like natural parenting, natural parents do not have that opportunity. And there was a judge in Texas in that case who really said it succinctly and did not reverse an adoption of some parents who were having an acting out child, a child they claimed could never bond to them or who was difficult. And the judge said, hey, that's life. Deal with it.
A couple of quick questions, and then these are have to be done. But if a practitioner is determined to, be on the cutting edge or at the, foresightful, what sorts of things should we be preparing for from a legal perspective? And a second question would be, if you're aware of a birth father who's really being ripped off, what advice do we give them, or how do we help?
Well, just as somebody said earlier, you want to make sure that they're informed that they have a right. They have some rights here. You might be in a position of a conflict of interest, but you want to make sure that they can seek independent counseling, legal counseling or other counseling, so that they can find out what those rights are and make an informed decision. Are they going to be involved in the process of placing the child for adoption and consenting? Or if they have some reservations, you want to make sure that they're informed of what they're doing when they are presented with that pen and paper to consent to an adoption, that they do it with full knowledge that this terminates their parental rights, that if they need to revoke this consent, it's going to require a court order to do so, and that they don't have the parental responsibility of support and other parental obligations. But I think that as social workers, as attorneys who are involved in the adoption process, rather than, as has been said, keep them out of the process, we need to bring them into the process, because I don't want to repeat verbatim what has been said, but it keeps coming up. It enriches the process to the point where it benefits everyone to have that birth father in there. Certainly the security of the adopted family. Better to have some birth father who's involved early on, who knows what's happening, than to have this Mr. X out there who could sort of upset the whole adoption. And then that's when we read about those things in the newspapers. And that's when independent adoption especially, gets a bad name for these, these risks, and all the money they spend goes out the window because a birth mother or birth father suddenly changes their mind about a placement, when that situation could have been totally avoided. My experience in over a dozen custody matters is, and they're not custody cases that arise out of adoptions that I facilitated, is that I believe that every one of them could have been prevented. Every one of them was unnecessary. Most of them dealt with adoption situations that should not have proceeded to adoptions at all. And so better to have that resolved early than later, as you all know. The other thing is that, again, the adoptee will benefit by having his or her story told and know that the birth parents were caring in their decision to participate, and that the background information is there, certainly the health information is there, it all falls in place, so that the whole adoption triangle is enhanced by everybody being there and not leaving anybody out.
When birth fathers headed for the hills, would we do better if we were connecting with them with male workers?
Maybe.
Yeah.
Just that last part.
The question is,
When birth fathers headed for the hills, would we have a better batting average getting them involved in the process early if we were connecting with them with male workers?
I think male workers have an advantage, and it's been my experience.
well, I am one, and I don't think it is that much of an advantage, to be honest. In fact, sometimes I think males can come across more authoritatively and actually be scarier. To me, the more crucial variable by a mile would be the attitude and the respect. And that certainly crosses sex lines easily, and a determination, and all the other good things are more crucial. I think we all, myself included, can find a lot of excuses for not doing this, a lot of them. I mean, lots of them. I can get myself off that hook real quick. But if we are resolved to do it, we will do it. There's just, we'll find a way. So it's not a matter really of how or, what's the magic formula or anything of the sort. It's a determination, I think. And if we have it, we'll get it done. A couple of last comments.
I had a question for Martin. What are the chances, Martin, of having a closed adoption open after 13 years or so?
You're talking about being open to contact from you or participation in some way.
Now, in some way, if it were to go to the courts, say for example, if I made if I made myself known to my son against the wishes of his adoptive parents.
Right now, I must tell you that unfortunately, you're out of luck. The courts are not going to be your help.
Even if the child had a desire to...
The child, as I understand it, is a minor, and the adoption is final, and the parents have now the parental authority to determine unilaterally almost what's in their child's best interest. And if they feel threatened by you and fearful of whatever, even though you may not be coming on to them with those intentions, they have the power at this point to do whatever they want. And if you were to spend your money to try to upset that in any way, you probably won't succeed.
Was it an agency adoption?
It's a tough agency. I know the facts.
Our agency is open adoptions and it pays to go back and
Right,
ask.
we open them up all the time
Yeah,
to find the
No,
children.
I've already gone to the agency.
Yeah, we won't mention who the agency is in this case, but they have already rebuffed him. It's a difficult situation, and the adoptive parents in that situation are going to succeed. So the other thing too, as I
Well,
tell...
the idea that I'm thinking of, I heard of a case where the adoptive mother came into the child's life. It ultimately went to court, and the court said, wait a minute, here's a 15-year-old child who obviously wants contact with her natural mother.
Mm-hmm.
She should have that. I guess it was up to the judge.
Yeah, it is up to the judge, but it's also up to the parents in those situations. And I think that the other thing about, again, turning to legal redress, before you turn to legal redress, I would think you have to exhaust your social remedies, your personal remedies, because hiring a lawyer and getting a letter or a meeting set up right away puts people in an adversarial position and would reduce the chances of success. Want to wrap up?
Yeah, I think.
Well, I think we did. Okay. Thank you very much, everyone.
This concludes this session.
Yeah, I'm going to put this together and do that.